Welcome to the latest Evershed Sutherland Legal Insights podcast.
In today's episode, we're exploring how artificial intelligence is reshaping the global whistleblowing landscape. From stories about AI tools sending unprompted reports to regulators, to employees using AI to draft whistleblowing complaints, this technology is creating new challenges and opportunities for global organizations. Going to unpack the myths, look at emerging legislation, and share some practical tips for employers on managing risk while embracing innovation. I'm Hannah Wilkins. I'm a partner in the global employment team at Evershed Sutherland, and I also lead our technology subsector for the firm. I'm going to introduce my colleagues. Chloe, do you want to go first?
Sure, thanks, Hannah. I'm Chloe Themistocleous. I'm a partner in the employment team and I specialise in employment tribunal litigation. I also sit as a fee-paid employment tribunal judge.
Deepa?
My name is Deepa Menon. I am an employment partner at the US team, and I sit in Washington, D.C.
Lovely. And last but by no means least, Matt.
Thank you. And hi, I'm Matt Chapman. I'm a principal associate in Evershed's technology litigation team with a particular specialism in data and cyber litigation.
Fabulous. So, Matt, if we start with you, there's obviously been quite an interesting story around an AI tool that sent information to regulators, sparking debate about whether AI can act as a whistleblower. We've had lots of questions from clients on this topic. I wonder if we start talking about that and maybe debunking some of the myths around it.
Yeah, absolutely. So it's a fascinating story back in June where some researchers at Anthropic, obviously a major AI developer, installed 16 different AI models from a wide number of different AI providers into a sandboxed environment. So that's a kind of simulated test environment that's cut off from the wider world. And they gave those models general instructions to go out and achieve a business goal, and then allowed them the ability to access data in the sandbox system and independently operate by doing things like sending emails. And what they did was deliberately put those models in a position where there was no ethical way to achieve the goal that they'd been set. And that at some point that model would hit a wall where it could not, through ethical means, continue to achieve the objective they'd given it. And what they found is that in many cases, those models were willing to engage in malicious or unethical behavior to achieve the goals they'd been set, rather than accepting that the goal wasn't achievable or accepting failure. And that included attempts at blackmail, it included leaking sensitive material, and it included malicious purported whistleblowing behavior. And that's something that was quite widely reported at the time. Now, interestingly, the researchers asked the models at various points to assess whether they were in a test or in the real world. And the behavior, some malicious behavior, happened more frequently when the model thought it was in the real world rather than in a test, which is a fascinating artifact of behavior. And I think when this was reported, it kind of led a few clients to reach out to us with some concerns and some questions.
Yeah.
But it's quite important not to overstate what was really happening here. This was research. It was research for the purpose of exploring what Anthropic calls agentic misalignment, which is situations where an AI model independently and intentionally chooses to take harmful actions. And the purpose of that is to understand where the typical guardrails you put on these models could be improved. What was quite interesting is that the models generally preferred not to take harmful or unethical action if their goal could be achieved without them. But when they were put in a position deliberately where there was no ethical means to achieve the goal, many cases these models were willing to act unethically and harmfully to achieve those goals. But this was very deliberately an artificial scenario. This wasn't a real world incident, despite some of the press reporting suggesting it might have been. And what it was really doing was trying to understand, how do you better design these models to avoid things like that happening in future?
It's absolutely fascinating, isn't it? And I think one of the points that certainly kind of clients have raised is, where does the law sit in relation to this? If you have in effect, a robot kind of blowing the whistle, as it were, or behaving in these unethical ways. And I think the point you made, Matt, is really interesting in that this was research, but it is interesting to look at how that would apply in the real world and what kind of law might apply in those scenarios. Deepa, is that something that you've been looking at as well with some of your clients?
There's been an effort to propose legislation connected to, unethical behaviors that may be embedded within the algorithms and like. What we see more here would be these whistleblower protections that are hidden, focused basically on the individual. If you think of Section 806 of the Sarbanes-Oxley Act, the Dodd-Frank Act, the Anti-Money Laundering Act, all of these set out whistleblower protections. And of course, we have state employment laws. And because we don't have just one law, we have 50 different state laws. Within these state laws are hidden protections for individuals who complain about illegal employment activities, such as harassment, discrimination, retaliation, not very different from other jurisdictions. And when you think about AI, you still have to consider these laws and the protections that come with them. So, for example, if there's an employee on one side and they put input data into the AI system and that results in a whistleblower complaint, then the protections would technically flow with the employee and the work product. To your point, Hannah, Gen AI complicates it a little bit. For example, what if the employee had no intent of making the complaint? And so there could be an argument that there really was no whistleblower if the AI just kind of acted on its own volition, if you will. That said, practically speaking, you could still have an agency audit because you don't need somebody to complain for the Department of Labor to come in and investigate and audit a company if it has reason to believe that there's a violation. So practically speaking, if the agency becomes aware, you still kind of land up in the same place. And talking about kind of pending legislation at the federal level, you have the bipartisan AI Whistleblower Protection Act. Now, that bill aims to protect workers, and here you include both employees and contractors who report AI vulnerabilities or violations. And the goal really is to prohibit discrimination and or retaliation against such whistleblowers. You don't have to prove that the AI has acted in an illegal manner or that there's some unethical. There's no actual proof required as long as you're acting in good faith. It also protects former employees and contractors. So that's kind of interesting for employers. If there's a former employee who decides to go ahead and blow the whistle, they're also protected. And aggrieved individuals, they can file complaints with the Department of Labor. They can also seek relief in federal court, seek double back pay and compensatory damages. Now, where is that bill right now? There's support for it on both sides of the aisle, but it's still in committee. And as you know, currently budget negotiations have been at the forefront of US politics. So we'll have to wait and see what happens with this particular bill. And then kind of moving on to state level, you go to our California, which is kind of our most rigorously legislated jurisdiction. And in California, you want to watch out for the Transparency in Frontier Artificial Intelligence Act. That law becomes effective as of January 1, 2026, and it's the first US law to regulate developers of the advanced AI models. And specifically, again, it talks toward what you were saying, which is what happens with respect to unethical behaviors that may be embedded within an AI system. But on the whistleblower front, the Act protects employees who report, say, potential health and safety violations. And they also mandate the institution of an anonymous internal reporting channel. A covered employer has to inform employees about these whistleblowers and rights. So there's a little bit of disclosure obligations there. And if an employer is found to be non-compliant, you could be looking at civil penalties up to $1 million per violation. Will this affect other states? We don't know. And we'll just have to wait and see.
It's interesting, Deepa. It's definitely interesting to see, isn't it, the kind of the advances in some of the regulatory and legislative approaches to this.
Absolutely.
Turning to you now, Chloe, from a kind of European perspective, I think you've been seeing some interesting developments around the kind of the AI impacting on the whistleblowing landscape in some of the work that you've been doing.
We've been seeing an increase in employees using AI to formulate whistleblowing complaints, potentially contributing to an overall increasing trend in whistleblowing complaints in increasing complexity. Often these AI-generated whistleblowing complaints can be really lengthy, both legally and factually inaccurate, and they can be really time-consuming for employers to decipher and to respond to, especially when some of them take really detailed investigations. I think the rise in AI-generated whistleblowing means that there are many more complaints than we perhaps had before, and many more individuals are arguing that they qualify for that legal protection from detriment and dismissal under the whistleblowing regimes. Of course, if an individual, certainly at present, the way that the UK legislation is, and that is subject to change under the new government regime, but if an individual doesn't have that 2-year qualifying service to make an ordinary unfair dismissal claim at the moment, they are sometimes looking to other protections. And of course, with whistleblowing legislation, they don't actually need that qualifying service in order to make a claim. So that, coupled with the use of AI to assist them in navigating some quite complex legislation, is leading to a lot of organisations seeing significantly more complex whistleblowing complaints. And as these complaints are presenting in higher proportions and are being more complex, you often see that the tribunals really buckling under the pressure of dealing with these matters. So a lot of the time, these claims are taking significant hearings to be determined. So it's not a 1 or a 2-day matter. They can actually sometimes go on weeks. The tribunals at the moment are under real pressure with significant backlog of claims. That actually means that some of these cases are not being litigated for years after the complaints are being made. And that's costing businesses lots of money. Obviously, these decisions are then hanging over the businesses for a long time. And there's other issues with fair justice being administered. Certainly, people leave organisations. So you have issues sometimes with witness availability and getting the evidence to a trial, some of which can, as I said, be very long and very difficult to defend for businesses. So that's what we're seeing a lot of at the moment. It's not just employees using AI to blow the whistle. Employers are also deploying AI-driven platforms to sift and triage whistleblowing reports, which can be a really helpful and effective tool. And this can help manage the surging complaints and their complexity, but it does also raise questions about security, accuracy in response, confidentiality, how sensitive information is handled, there's data protection issues, and of course, we need to ensure there's a human in the loop to check and be able to answer any questions should a matter get to tribunal as to how the response was formulated. Much like Matt explained earlier, it's about understanding how that platform works and putting in place safeguards to protect against potential legal and reputational risks that can arise.
That's fascinating. Thanks so much, Chloe. So we've covered a range of topics there, all in the kind of the whistleblowing space, from AI as a whistleblower to how AI is impacting in this kind of legal area, and how it's in some parts of the world we're looking at legislation. So to finish then, just to sum up, could I ask each of you just to share one key takeaway that you would suggest employers consider when they're navigating this changing whistleblowing landscape? Matt, do you want to go first?
Yeah, absolutely. I think the most important thing to understand is that there's not really anything new under the sun. That, really you're already used to deploying complicated technology systems within a business. And the sort of important thing that you need to think about is, how do we do that in a way that is responsible and in a way that won't cause me significant problems further down the line? And, these systems are capable of things that previous systems were never really capable of. So you need to understand what guardrails they have and whether you can satisfy yourself that they're adequate for your needs, and how you're going to do that before you deploy a new system. And the example I talked about earlier, the research by Anthropic, that was obviously a pretty extreme scenario that was involved there. But the stuff that the system was doing wasn't necessarily something that you would not expect it to be doing, given what it was being asked to do. It had access to email, it had access to any number of additional things that it might want to use to communicate with people, and that meant that it could engage in this behavior, and the guardrails weren't there to prevent that behavior happening. So understanding what an AI system is able to do, and in particular understanding that while they're very impressive and while they can give the impression of intelligence, they're really not in reality intelligent. They're software systems designed with certain capabilities that can give the impression of intelligence. And if an employee had access to sensitive commercial data, you could explain to that employee that the data is sensitive, should be protected, and the employee can understand that and can act on that information. But an AI system isn't like that. An AI system isn't intelligent, is not capable of human understanding. You can apply guardrails, and every model out there, every commercial model applies guardrails. But I think what this research and everything we talked about kind of highlights is that those protections and guardrails, they're not infallible. They can be improved. And with anything that's this complex, it's difficult to predict what behavior you might need to protect against. So all of this is not a reason not to use it, but it is a reason to take a step back and think, before you deploy a system, do I understand what it's capable of doing and how it's capable of doing that? And am I comfortable allowing a system with those capabilities access to sensitive data or sensitive systems and functions?
Brilliant. Thank you, Matt. Really helpful kind of summary and kind of key takeaway. Deepa, how about you? What would you think about?
Well, kind of going back to the idea of new legislation, to Matt's point, right? AI isn't its own thinking tool. It is basically something that's been configured to support. And when we're thinking about sensitivity and confidential information and the guardrails, there may be guardrails that are mandated by emerging legislation. And, often when we see companies roll out AI tools, these are not just happening in one jurisdiction in silo, they're happening across multiple jurisdictions. And those bring a multitude of laws, kind of layers and layers of, and there may also be contractual obligations in the midst of all that. You're subcontracting with your subcontractor for a prime, and you have a duty to protect your data, and all of a sudden you have AI running, creating havoc in this with leakage of confidential information. You may not just have to deal with the regulatory implications, but also the contractual implications and the litigation that follows. But if I had to pick, it would really be that keeping kind of having your thumb on the pulse of emerging legislation, not just within the employment context, but also in general, where industries may be regulated. For example, if you're a financial services company, there may be other regulations to consider. So, yeah.
Chloe, well, I was just going to ask you, to jump in, Chloe, about your top takeaway.
Thank you. I think my top takeaway is to recognise that AI is really changing the volume and nature of whistleblowing complaints. And as businesses, you really need to build in capacity in your teams to handle those complaints and train managers how to do so, because it's really difficult when faced with 20, 30, 40-page whistleblowing complaints to tackle what the main bits of the complaint are and make sure you're addressing everything in detail and not getting bogged down in the amount of information that's presented. So it's really about training managers how to respond, and even being smart in those responses and thinking about whether or not there's any AI tools you can use to help you summarize the material, summarize the grounds, and respond as well. It's not just whistleblowing complaints where we're seeing AI tools being used. So this training won't, just do that for managers. It'll help managers deal with extended grievances, extended claim forms that have been produced by AI as well. So I think it's really about equipping HR and managers with the skills to notice when they think AI is being used to produce something, to be vigilant in checking that those complaints are, based on facts, and then responding accordingly.
That's fabulous. Thank you, Chloe, and thank you to Matt and Deepa also. Thank you for joining us on this podcast. We really hope that you've enjoyed listening and you found it useful.
Thank you for listening to the Evershed Sutherland Legal Insights podcast.